Well, welcome everybody. I am Jeremy Kidd, Associate Professor at Mercer Law School, visiting Associate Professor at Catholic this year. On behalf of the Executive Committee of the Section on Agency, Partnership, LLCs, and Unincorporated Associations, welcome to our session on entrepreneurship and the entity. We're excited to hear from our four panelists about the ways in which our various institutions, legal, cultural, social, and so on, affect the entrepreneurial process. We'll hear from our panelists in the following order. First, Jordan M. Berry, Professor of Law and Director of the Center for Corporate and Securities Law at the University of San Diego School of Law. Second, Priya Bhaskaran, Assistant Professor of Law and Director of the Entrepreneurship Law Clinic at the Washington College of Law at American University. Third, William J. Moon, Assistant Professor of Law at the University of Maryland Francis King Carey School of Law. And fourth, Paige L. Wilson, Assistant Clinical Professor of Law at The Ohio State University Moritz College of Law. Professors Moon and Wilson were selected from our call for papers. Professor Moon will be sharing his work on anonymous companies, and Professor Wilson will be sharing her work on Midwest venture deals. Each panelist will speak for 5 to 7 minutes. After they have all had a chance to speak, we will move into a question and answer period, where I hope we can have a great discussion about these important issues. Professor Berry, if you would start.
Thanks so much. It's a pleasure to be here. Thank you for hosting us, Jeremy, and the section as well. And I'm excited to talk to my co-panelists. The general plan for today is for us to speak pretty briefly and to have a lot of time for kind of Q&A and back and forth, which I'm excited about. So I will keep my remarks brief. Let me start with a big picture point that I think everyone here will agree on, and I think everyone at home. I'm a big unifier, so it sounds good to me. I think entrepreneurship is generally a good thing. I think we like it. I think there are a lot of reasons for that. I think that it can empower people. I think that it can be good for the economy in terms of encouraging dynamism. I think that a lot of people talk about innovation and entrepreneurship. So I think we can sort of start with that base premise for the most part, although if I'm wrong, it'd be fun to hear other people disagree with me on that one today. And so I think starting from that, the next move we kind of make as a society is we try to encourage it. If you like something, you try to encourage it and get more of it, which I think is sensible and makes sense. And there's a lot to be said for that. But I do want to kind of talk about one aspect of our efforts in this respect that have some problems. So in particular, I want to talk about complexity. I think that a lot of what we end up trying to do ends up making things complicated, and that can have a bunch of negative effects. And to ground this a little bit and be a little less abstract, I'm going to kind of use tax as an example because obviously I want to go with the biggest crowd pleaser I can think of, and tax is definitely the way to go for any audience. So one thing that you get from these kind of complicated interactions, I mean, you could pick other things besides tax, but we'll stick with that, like I said, is you get a lot of unexpected consequences. So one simple example of this is there are a lot of tax provisions out there that are designed to encourage entrepreneurship or innovation or various specific industries, and they can interact in ways people don't expect. So one good example of this is that for many years, video games got tremendously great tax treatment because they get all the benefits of being in technology. They got a bunch of benefits of being entertainment, things like that. There are a lot of overlapping provisions that weren't really intended to work this way, but they did. And so you have members of Congress getting out there and talking about how bad violent video games are, and then also giving these huge tax incentives they didn't realize they were giving. So that's like one easy example that you always get with complexities, kind of unexpected consequences. Another point, which I think some of my other co-panelists can talk about more than I will probably, is that as you make things more complicated, you're starting to tilt who gets benefits. As it gets harder to take advantage of these systems and there's more opportunity to be clever and cagey and sophisticated, then you start punishing people who aren't as good at that. And I think that raises real issues of equity, especially if you're thinking about entrepreneurship as a way of empowering people who may not have other good options. Like if you're saying this is a way that you can get out there and to improve your lot if you don't have certain other advantages. This sort of say a lot of these are kind of sophisticated points, sort of baked in advantages that are sort of doubling down on instead of counteracting. So that's sort of a problem there too. Another issue is that, especially when you're dealing with these big complicated systems, people start to get worried about gamesmanship. And so if you're trying to fight gamesmanship, then you have to make your provisions more complicated and also more narrow. You want to try and say, oh, we don't want those people to get benefits for doing this kind of behavior we don't like. So you have to sort of build in all these guardrails. This is a very common issue in tax. I do this all the time. And it's understandable that you'd want to target your benefits and prevent things you don't want from happening. But it's particularly difficult in the context of entrepreneurship and innovation. Like part of that is because we're talking about kind of new and developing areas. So the industry may simply be in flux, and it's hard to sort of figure out how it will develop and who you want to encourage and how. The same point applies to technologies. Maybe a technology looks good initially, but it's actually not as promising later on. How do you kind of deal with where you put your incentives to sort of encourage things in the right direction? It's easy to miss. And if you're trying to make a targeted approach that's sort of narrow, you might end up putting all your incentives in the wrong spot and not really getting any bang for your buck, which is a problem. And on top of that, government is good for many things, but it's not known for being super fast necessarily in terms of changing direction. So it can be hard if you miss with your initial target to then make some new bill and kind of retarget things. In theory, it's possible, but in practice, it can be difficult. And this is compounded in a couple of ways by incumbents. So if you're thinking about entrepreneurship as a way of fighting incumbent power, well, incumbents like their power, and they're going to use these rules to help themselves and sort of limit competition if they can. They're going to kind of make things more narrow to make it harder for startups to fight with them, in a sense. And if you are too late in changing course, if you have a successful startup, it becomes an incumbent. Uber was a small upstart for a while, and now I wouldn't put it that way. So depending on how long it takes to change your rules, you end up with kind of, you're going to try and encourage startups and you end up kind of entrenching incumbents instead. So that's a problem. And so sort of big picture, all this complexity that we're adding in and all these problems, it also reduces your efficacy. What you're actually getting from your policy, these layers of complication reduce that payoff. And this is clearly easily visible, I think, with sort of smaller players in terms of, how much are they thinking about all these legal issues. But even at the most sophisticated end of things, I want to be clear on this. There's a lot of literature about how Silicon Valley startups, which are large and well-financed, have repeat players, have venture capital. They don't do a lot of tax planning. Some of the sort of most obvious things you'd expect them to do for tax planning, they often kind of don't do it. So even at the high end of things, there's reason to believe that the complexity kind of can get in the way. And just sort of bigger picture, the larger point I want to come back to is that entrepreneurship is hard. It's a lot of stuff you've got to do to be a successful entrepreneur. And one would think that big picture, we want to make it easier and reduce some of these moving pieces. We don't really want to encourage competition on sort of legal avoidance and legal navigation fronts. It's not really a policy goal I think we want to be pursuing. Why would you want to add to the list of skills that entrepreneurs are going to need to be successful? I think you want to go the opposite way and kind of grease that path and make it easier for people, not harder, fewer moving pieces. And I'll just end with sort of a very brief comment about another kind of debate in the area, which is sort of about there's a lot of focus on how we want things to be customizable, and you can kind of build any sort of arrangement that you want as a company, as you're sort of negotiating with stakeholders, sort of a lot of flexibility in structuring the company. And there's a lot to be said for that, but there's also a lot to be said for simplicity instead of customizability. Simpler things are easier to understand. They're going to be harder for people to manipulate in ways you don't want them to do. They're going to be harder for people to lobby on. It's easier to see that sort of dynamic. And I think people often learn through experience, and we shouldn't assume entrepreneurs are always repeat players. We should sort of make it easier to start out in that area and then live and learn from there. And it's easy to overstate how much people know, as we all know from grading our exams in the last few weeks. So I think I'll end about 10 seconds early and just say thank you.
Professor Bhaskaran, I believe you're up.
Great, thank you. So I'm going to actually pull from something that Jordan just said, talking about entrepreneurship as a means and vehicle for equity and empowering people. So, given the anti-democratic events at the nation's capital, and I teach at a DC law school, which I believe were made impossible in part because of continued structural injustice in the US, I feel very obligated as a lawyer and as a professor to emphasize our responsibilities to address these interlocking systems of subordination that impact every area of law, with entrepreneurship being no exception. And these systems really divide us. into haves and have-nots, often along the lines of race, gender, class, and even geography. So my time today will be spent on focusing on how I have incorporated these discussions and topics into my classroom in an entrepreneurship law clinic. And I'm specifically going to be using an example from my time teaching at West Virginia University to really highlight that the demographics of a law student body or the demographics of your fellow faculty should not deter you from engaging in these really important, timely, and rich topics. So I think the first step is being honest, transparent, and intentional. So this is language that I place in my syllabus, to make sure that my students are on notice, that we are going to be engaging in these topics as part of seminar, that it is essential to the development of them as critical thinkers and lawyers. And obviously it's going to be part of their seminar grade. And we also cover this extensively during our orientation so that they can evolve beyond being mere legal Zoom, purveyors of contracts into really thinking about what types of contracts they're writing, what are the systems that they need to operate within, and what are the barriers that they really will encounter in practice. So here's a really practical example of how I, and I think others, can engage meaningfully with this topic. So a very, very easy entry point to discussion is access to capital and the disparities that impair certain types of entrepreneurs while preferencing others. So, in my clinic, we have a class dedicated to the substantive topic of, small business financing, right? So it covers the basics of loans, bootstrapping, investment contracts, we talk about safes, we talk about convertible debt, all of the kind of like nitty gritty legal details, because we are going to be doing this work for our clients. And this really kind of lays the foundation to move from discussing these practical legal tools into, what does it look like in application? Are there structural barriers for your clients in rural West Virginia, right? Or in Detroit, Michigan, as a Black entrepreneur, actually being able to implement or use any of these tools. And so I assigned this reading, which is a report from the Kauffman Foundation. And their research, which is drawn from a series of surveys, really documents everything from the difficulty in securing traditional loan money, right, from lending institutions for women and BIPOC entrepreneurs, and also pressure even from private investors to relocate, for successful entrepreneurs, to relocate from rural areas or other less desirable geographies in order to secure continued funding. And the report also starts to address the racial impacts and its racial wealth gap and its impacts on lending and bootstrapping, like, credit scores for borrowing, in general, the value of your home, which can be impacted by things like redlining, and how your bank really can evaluate your risk as a person when evaluating your business idea for a loan. So to really drive it home, I like to do an in-class activity. And before we really go into the in-class activity, we do spend some time talking about historical issues and barriers, like redlining, right? Because while it was explicitly race-based, it also disenfranchised rural areas from investment. So this legacy, manifests in like spatial disparities within geography. So for something that people don't often know, or things like infrastructure funding, right, is very tied to redlining. And there's bad infrastructure in Flint, Michigan for water. There's also terrible infrastructure for water in West Virginia. And a lot of that legacy can be traced to redlining, right? So who's gonna give you a loan for your business if you don't have potable water? So who are your customers gonna be? How are you gonna build your tourism industry? So then to personalize it, we have students apply these barriers to their own imaginary venture, right? So how can you bootstrap your West Virginia-based rural business venture? And my students found themselves like unable to successfully bootstrap, right? They rented, their folks owned homes in rural West Virginia where the average housing value is like less than $100,000. And that's if you own your home and you feel like you could mortgage it. People who lived in like non-traditional housing, like mobile homes, you know, they didn't even have that option. And then the presence of things like septic tanks totally destroyed the ability to lend against it, right? All of these things that they had never thought about. Plus they had student debt, plus they had car payments, you know, suddenly it's looking really, really hard for them to bootstrap in the traditional way that we think about it. And I found this as an opportunity to really explicitly discuss race, class, gender, and force a conversation about structural barriers in a very productive way as a woman of color teaching in a predominantly white law school and a predominantly conservative student body. And we were able to have really great discussions and I think like ultimately really like start planting seeds for what I hope to be changes in the way that we approach these structural barriers. Because my students are going to go forward from West Virginia and be members of the state bar. You know, some of them will run for office, some of them will be state regulators and have an opportunity to sort of sit with and think about these issues and what they really mean. And so finally, I would be remiss if I didn't mention that everything we did in class definitely translated to our work. So from sort of talking about these structural barriers, it was a great way to talk about, well, how do people really raise money when there is no ability to tap into the sort of traditional markets? And honestly, many of them engaged in creative financing efforts. You know, there was a lot of bartering of goods and services. You know, there was this whole untapped ability for intrastate securities that we were starting to explore. There were pre-sales of goods and services, and there were small businesses trying to support each other with investments in exchange for a return in profit sharing as opposed to equity. So eventually what we were able to do was put together a workshop and a series of materials with the West Virginia State Securities Office. And we did it in the state capitol, and my students were actually able to do this seminar and this workshop, walk entrepreneurs through these various non-traditional financing options, help them issue spot some of the legal issues and how they would need to navigate it. And ultimately, we created a bank of sample documents for these businesses that were starting to work through this, and we were able to connect them with either low bono or legal aid attorneys who could help them. So, you know, I think in this very tumultuous moment among this endless pandemic, you know, we are at a meeting, at a convening of law professors from across the country. You know, it's imperative for us to, you know, think about how do we further justice in our fields, you know, and just because something isn't on fire in our field in a very visible way doesn't mean that there aren't problems with equity that we can solve, that we can inspire our students to solve. And so I think I'm gonna end it right there. Thank you all for your time and for listening.
Thank you, Professor Bhaskaran. Professor Moon?
Thank you so much. So my project is called Anonymous Companies. It's a very early stage project. So I'm mostly looking forward to your feedback, but it's a project sort of designed to broaden our conception of modern business entities, not just as this asset, as this device to accomplish goals of limited liability and entity shielding, but as an important privacy device that enables certain types of enterprises that would otherwise not exist, at least to a certain extent that we see today. Just to dial back on how the project got started, while I was working as a law firm associate in New York, I was just blown away by the sheer number of LLCs and LPs and private corporations that were incorporated in offshore jurisdictions. And one of my major sort of research agenda for my past several papers has been documenting the rise of offshore jurisdictions in serving as providers of corporate charters. Now, those projects focused on public companies, but for this particular project, I wanted to focus on private companies formed in jurisdictions like Delaware, Wyoming, Nevada, and the Cayman Islands, where you don't need to disclose the beneficial owners of those enterprises. Now, of course, this is a phenomenon that you've seen a lot through reading newspaper headlines in the aftermaths of the Panama Papers and the Paradise Papers, which has been made into a Netflix movie called The Laundromat, which is really worth seeing. Initially when I started the project, I think I wanted to sort of jump on this bandwagon and sort of critique this. But as I dug deeper into this phenomenon, I began to realize that there might be socially beneficial dimensions to anonymity associated with modern business enterprises. So I sort of broadly bucket these privacy interests into two categories. One is what I call enterprise privacy interests, and it's this idea that the firm value might be enhanced if the owners, the true owners or investors of an entity remain hidden from the public. Now, this might happen because of a market failure of some sorts. That is, maybe the end consumer chooses products or services not based on their quality, but based on the immutable traits of the entrepreneur for some of the reasons that Priya just discussed, along the lines of race, gender, or sexual orientation. Or it might be because a private actor might want to take advantage of information asymmetry. Just to concretize with a couple of examples, one example of enterprise privacy interests is the use of anonymous companies by certain Black entrepreneurs to conduct certain e-commerce enterprises through anonymous LLCs. So one example of this is this host of iHeartRadio's Black Entrepreneurship podcast, where the host, who describes themselves as a black dude with bald hair, who sells high-end beauty products, chooses to operate the company anonymously through an LLC formed in Delaware. And he actually tells his listeners to do the same, to sort of evade some of the systemic racism that they face in dealing with business partners, investors, and consumers. Of course, enterprise privacy is not just limited to natural persons. So anonymous companies have actually become a mainstream way that companies like Google, Facebook, Disney buy large pieces of land. So Disney actually pioneered this in the 1960s when they purchased land in what now has become Disney World in Florida, where they didn't just show up and say, we're Disney, we're buying the land, which would lead to holdout problems, but instead deployed anonymous shell companies with weird names to buy up land. And the second bucket of privacy interests that I explore is what I call investor privacy interests. This idea that investors or owners of enterprises might wish to remain hidden from the public because of certain reputational costs or literally physical potential violence against them. This is an area that's really, this happens a lot in morally contestable industries, such as the porn industry. So we still don't know the true owners of some of the largest pornographic websites in the world. That actually rakes in more revenue than Netflix. Another really fascinating story that I'm exploring in the project is how the first abortion drug got manufactured and deployed in the United States. So this drug, mifepristone, was actually approved for use in France in 1987. But this was a time when, because of anti-abortion activists, no pharmaceutical company was willing to touch it to do the clinical trials necessary to get FDA approval. And people who believed in female reproductive autonomy got together, formed Cayman Islands entities to protect the identity of the investors and the managers in order to form what's now known as Danko Laboratories that led to clinical trials pooling of $50 million that it took to get FDA approval in 2000. So the project really uses these examples not to glorify shell companies, but to demonstrate that there might be socially beneficial uses of anonymity and that current policy frameworks that's really designed to sort of say, okay, let's just reveal, let's have public registries for all of these LLCs and corporations, which is the approach that Europe has adopted, might not be actually desirable. And there needs to be a more serious discussion about balancing the need to harness anonymity along with protecting our interests against some of the illicit activities that are facilitated by anonymous companies. So I'll leave it there, and I look forward to your questions and comments.
Thank you, Professor Moon. We'll now go to Professor Wilson.
Great. Thank you so much for having me. I'm looking forward to our discussion. So I've been working on a project called Midwest Venture Deals, and there are two moves that I'm making in this paper. So first, I want to explain how and why venture deals in the Midwest look different from venture deals on the coasts. And then second, I suggest that these differences are likely to dissolve as the Midwest venture ecosystem continues to grow. So I'm both zooming in on the regional differences and then arguing that those differences have been converging with Silicon Valley in New York and Boston. By way of background, my training is as a startup and venture capital lawyer in New York City. In 2018, when I joined the faculty at Ohio State and started networking with local startup lawyers here, I discovered that Midwest venture deals look a little bit different from coastal venture deals, mainly in that they include more investor-friendly terms. I was puzzled by these differences, and I really wanted to find out, do they represent a broader pattern here in the Midwest? Are there good reasons for the differences? And then are they going to stick around, or are they going to get rubbed out as the Silicon Valley style venture capital deal becomes the national model to follow? So to look into these questions, I spoke with 25 startup lawyers and 2 investors. The majority are based here in the Midwest, in particular, what we would call the Great Lakes states of Ohio, Michigan, Indiana, Illinois, Minnesota, and Wisconsin. And then several are based in Silicon Valley, New York City, and Boston. So these coastal lawyers were my controls and standard practices are in the major innovation hubs. So here's what I found. So early stage venture deals in the Midwest are more investor friendly and risk averse. And by that, I mean that Midwest deals are designed to give investors greater control over startups and increase returns on an early exit, typically an acquisition after several years. So greater control comes through board representation, veto rights over certain actions by the company, and redemption rights that investors can use to force a company to sell, typically after about 5 or maybe 7 years. And then how do these increased returns on an early exit come about? Through lower valuations on the companies, smaller amounts invested overall, features like accruing dividends, which are not typical on the coasts, and participating liquidation preferences. And what do all these features do? They basically give Midwest investors a greater financial upside, greater returns on an early exit, an early sale. And so why do Midwest deals look like this? There are 5 main things that my interview subjects pointed to. So one is leverage. Everyone talked about how Midwest investors have greater leverage. There's just not a lot of competition out here. They are big fish in a small pond. 2 is the influence of private equity. So private equity is big in the Midwest, particularly in Chicago, and classic PE style deals are more heavy-handed takeover style deals. And so if you have investors and lawyers with a background in PE, they want to make their venture deals look like PE deals. 3, the lack of big exits. So the Midwest still hasn't seen a ton of huge exits. There have been some, Groupon went public, Duo Security just had a big sale a few years ago. Root Insurance here in Columbus just went public. But there are not enough successful large exits to warrant the same level of risk-taking that you see in Silicon Valley. 4 is culture. So there's this cultural element that a lot of people point to. Here in Columbus, everyone calls it the Midwest mindset. And that is a mindset that encourages startups to grow slow and steady, also encourages investors not to fail and just to see some kind of return. And some say that this approach stems from the farming and automotive industries, right? The more grow slow, conservative, you don't want your Honda to blow up. So you got to make sure that it's built right. And then finally, the last thing that my subjects pointed to was differing professional expertise. There's just not a lot of coastal or coastal style investors and lawyers out here in the Midwest. So there's less familiarity with how to do sort of Silicon Valley style deals. In Ohio or Chicago or Detroit, you might have an angel investor in a startup who made their money in real estate, and then they hire a private equity lawyer to represent them in a venture deal. And as a result, the deal might have these heavy-handed investor-friendly terms that the investor demands or insists upon. And then companies are just not in a position to turn that money down. Okay, so we know now we have several explanations for why early stage Midwest venture deals look different. And when I first started this study, I thought I would find even more differences, but I actually found more convergences than I expected, and that surprised me. And so the next question becomes, okay, we know that there are some differences, but where is this all heading? Are we going to converge, or is the Midwest going to look different? It's not obvious or inevitable that the Midwest would converge. It's a very different place. And so there are several factors countering convergence with this West Coast model. And among those are comparatively fewer resources. So there's just less capital available. There's less talent available so that startups can scale. There are market dynamics I mentioned that favor investors. There's that regional culture I mentioned that encourages slow, careful growth. And then there is the relatively small number of true startup lawyers in the region. So there just isn't the deal volume to support a lot of experts on startup law and to sort of copy that template that you see on the coast. They just aren't familiar. There are also a number of factors that are driving convergence. So in the Midwest, there's increasing access to online education. You know, you can download some of these form contracts, form notes, form safes, read investor blogs, see videos from the big firms in the Valley. There's more capital available, both homegrown in the Midwest, but also coming in from the Valley. There's an increasing number of successful exits that are shifting market dynamics in favor of companies, like Root Insurance going public, I just mentioned. And then there's pressure on the VC industry to lower transaction costs in these deals by adopting a uniform set of practices. And then the adoption of these practices is migrating to the Midwest. In recent years, there's been increasing convergence. Midwest deals are looking more and more like Silicon Valley style deals. And I think if Midwest VC continues to grow, we can expect to see more convergence. So in short, this summary, this study finds that regional culture and market dynamics are at the root of these differences. And as the Midwest VC ecosystem grows and matures, these differences have begun to disappear. And so it looks like aspiring ecosystems do adopt the norms of mature venture capital ecosystems over time. And at this point, I'm happy to turn things over to Jeremy. I look forward to our discussion.
Great. Thanks, Professor Wilson. So now we will move on to our question and answer period. There have been a few comments made in the chat, and I will try and get kind of sort through those and identify which ones were intended as directed towards the panel. I thought I would start by allowing each of the panel members, if you want, there's no pressure, but if you want, if any of you have questions that came to your mind while your co-panelists were talking, I'd like to give you the first chance at asking those questions before we move on to other ones. You're always free to jump in at any time if you've got a comment or a question you'd like to ask, but I think I thought I'd give you the first shot.
If no one else wants to, I can talk. I'm a law professor, I can always talk, right? So Paige, something you mentioned that was really interesting was when you were talking, I was wondering about the idea of Silicon Valley VC firms kind of moving into the Midwest market. You talked about that a little bit at the end. So, you know, one might think that if terms are better for investors in those areas, investors would move in and you'd kind of get a increase in investors and you get some change in terms. On the other hand, you also mentioned that the Midwest companies haven't had the same kind of growth ethos that you see in Silicon Valley, and that might be a deterrent. And also, I would think that just sort of the depth of your network in a particular area in VC would be helpful, and that may be hard to recreate that if you're in Silicon Valley in the Midwest. I just wonder if you could talk a little bit more about how you've seen this. You talked that there was some moving in, how that's kind of been playing out, and how those different issues have sort of been an issue or not been an issue, or how those are kind of changing.
Sure. Yeah, happy to respond to that. So you're right that there has to be a good reason for investors wanting to come into the Midwest. It has to be attractive. And for Silicon Valley investors, there are a few things going on. One, in Silicon Valley, it's getting super saturated. There's just so much money and there are not enough companies to invest in. So they've started to broaden their reach. And this is greatly facilitated by things like Zoom, even by COVID. That's been an accelerant here, that you no longer have to live within walking distance of your investor. So they've gotten interested and started pouring money in here. And what makes it really attractive to them is these low valuations. It doesn't take as much money for startups to scale here, and they have that upper hand. And then interestingly, while these investors come in and there are market dynamics that do still favor them, even if it's West Coast money, the West Coast lawyers and investors still bring in West Coast terms. They don't do crazy things like accruing dividends and participating liquidation preferences. By and large, their term sheets are kind of packaged and templated. And then the other investors who come in alongside them here in the Midwest and their lawyers start to see these terms and see how things are done. And it starts to change their behavior in deals where they're not working alongside Silicon Valley. They sort of see the model and they're saying like, oh, it's okay to do it that way. All right, we'll try it out too, since that's what the pros are doing. Does that answer your question? Great.
And Paige, that it tied to that one of our observers, Mohammed Badisi, I'm sorry, Mohammed, if I mispronounced your name, but asked if there was anything that you identified that might have accelerated the convergence, or if it was organic, if there's any external force that kind of sped that process up. Sure.
So I briefly mentioned COVID, and I think that's one that's worth focusing on a little bit. Silicon Valley and sort of New York and Boston VC players are really excited about COVID in that it has given them greater access to these markets. It's eliminated these barriers. They're more willing to take these web chat type calls. And so it's been terrifying a little bit to the Midwest investors. On the one hand, they do want more money in this space. It helps. And on the other hand, sometimes they're losing deals now to these Silicon Valley players. So it'll be interesting to see post-COVID, is everyone going to still be as comfortable using video for everything? Is that going to be fine for companies to not fly out to the Valley? If so, then you might see, again, that increased uptick in West Coast money coming into the Midwest.
Any other of our panelists have any questions for your co-panelists?
I do. So my question is also for Paige. One of my questions, I'm only going to ask one. I have so many questions, but I will ask one. So the Midwest, like you said, the Great Lakes region is, I think very diverse in terms of like actual city size, right? So you have Chicago, which is the third largest city in the United States. And then you have, Detroit, Michigan. So I was wondering if you would notice, and then of course you have major university towns like Ann Arbor and, Columbus, right? So have you noticed any sort of sub-distinctions, I guess, within the actual size of the city and whether it's a stronghold city like Chicago or if it's something that belongs in the Rust Belt?
Sure. Yeah. So you really raise an interesting question there about geography, because the Midwest is not a homogeneous region, and what rural Wisconsin looks like and even parts of Detroit are very different from Chicago, which is flush. And it is true. I did find in my results that Chicago looks a little bit more like Silicon Valley than any other part of the Midwest. And again, I think that's just because they have more capital and sort of more exposure or expertise there. But you still see the same limitations as everywhere else, right? The experience of private equity, investors doing wonky things. Even if there's greater access to capital, it ends up like capping out at the Series B level instead of the Series A level elsewhere. And then by and large, I was looking at mostly cities, so everywhere from Minneapolis to Detroit to Ann Arbor and Columbus, et cetera, these hubs in the Midwest. So I wasn't focusing as much on rural areas, but I do think that the less densely populated any area you look at gets, the more rural it is, just the harder it is for it to be a sort of major innovation hub, and that it's just harder for startups to grow, period. Not even just the access to capital, but again, the access to talent, a lot of people see as a bottleneck. Just how do you grow a company if you can't hire people, if you can't recruit? That seems to be a major limiting factor.
Thank you.
I wanted to move to some, oh, sorry, Will, go ahead.
Can I ask a quick follow-up on that?
Yeah, of course.
So we've seen a couple of Silicon Valley firms start to move out of Silicon Valley physically into like Texas, for instance. Have there been efforts by some of the Midwestern states to attract some of those firms?
Sure, yeah. So here in the Midwest, we have one. So my old alma mater, I guess, Gunderson Detmer, has a small office in Ann Arbor. And the partner who opened it for her own reasons. She wanted to move back home to Ann Arbor, and she maintains a California practice as well. So it wasn't as much of a firm decision as it was a partner level decision. And other than that, there are no other true Silicon Valley firms out here. But as you mentioned, there are some Silicon Valley firms that have moved into places like Austin. And when I talk to all these Silicon Valley lawyers, I would ask them about the firm's efforts to move into other geographies. And by and large, they would say things like, oh, if it's a firm level decision, we don't really do it. There are a couple places we monitor, but there's just not the deal volume to support an office in most of these places. The economics just don't work for us. But at the individual level, some people have certain regional ties. And so, in some cases, these firms have opened offices just because it's of a convenience to a partner, not just Gunderson. I mean, Wilson Sonsini has done this too, or they look to pick up certain deals as well in other areas. And so that includes along the Acela corridor, because DC just has less activity. And it includes, there's a partner I know who graduated from college in Atlanta. So he represents a bunch of startups there, because why not? You get business wherever you can. But I don't think we're going to see the movement of these firms into these areas. It's a little bit piecemeal.
So, Paige, one observation from Mohammed Badisi again. He noted that in Pennsylvania there is at least risk capital in the form of co-ops and co-op financing. Do you see that as do you want to comment on that as a potential, maybe a precursor to formal venture capital, or maybe as an alternative in some rural communities?
Sure. So I'm not super familiar with that particular model. I think it's a little bit distance from venture, although Priya might have more exposure to it. But I will say that one of the things that has become more available to rural entrepreneurs or people who have other barriers to access is for building startups in these states, is that state funds have become very active. So you don't hear about this in New York and Boston and Silicon Valley. There's enough money already. But here in Ohio, there's been a big effort for the state to support entrepreneurs, and Illinois, Indiana, all the Midwest states have something, and they've played with different little toggles. So it might be some sort of tax incentive for investors, or it might be, accelerators nearby where companies can cheaply rent space and get sort of cheap state money as long as they can match it. And everyone's playing with a slightly different model. Even here in Ohio, we have 3 different models, one in Columbus, one in Cincinnati, and one in Cleveland. And so I think the state money is a really interesting thing. That would be a whole interesting other project to look at what's working and what's not, and how because there's just not enough private money to play with.
Thanks. So that was some really good questions. We do have a significant amount of interest for Priya to explain her class a little bit more. A lot of people in the chat excited about hearing more, but I wanted to really quickly, I just wanted to let everyone know I also want to hear more from Priya. There was an earlier question, or a couple of earlier questions for Will, so I'm going to hit those first, and then we'll get to Priya. So one was from John Coyle, who asked, Will, when you talk about respecting or keeping the identity of the company private, is it the identity of the company private, or is it the identity of the owners of the company? He says if it's the latter, then don't we already have a system that largely conceals the owners of private companies from non-government actors? Or is the goal here to make it harder for governments to identify the owners of a company?
Yeah, that's a really good question, John. So the idea is the latter, the concealing the identity of the owners or investors, and in some cases, manager of these firms. For the longest time in the United States, this was possible because, as you know, we leave corporate law up to the states. States decide the level of disclosures required. All you need is a handful of states. We have Delaware, Wyoming, Nevada that are seriously competing in this market for LLCs that offer basically, companies not to disclose ownership of any kind. But there was a recent Corporate Transparency Act that just passed as part of the defense bill that actually might be requiring ownership disclosures in the United States. This is part of a broader global movement to make everything transparent. And for instance, in Europe, it's a public registry, so you can't have any level of privacy. So I think we need to sort of strike an appropriate balance between do we just allow people to remain hidden from the public or the government? That's something that I'm still thinking carefully about. But I think at the end of the day, it just depends on the type of society that we want to live in.
And another question from Franklin Geverts. I hope I didn't pronounce that too terribly wrong. Said, any thought on how to design an empirical study to test the proportion of legit versus slimy motives for anonymity?
Yeah, it's really, really difficult. For my publicly traded companies projects, I have done some empirical stuff, but by very definition, a lot of this is hidden from the public. So it's really difficult to estimate the numbers. But we do know that there are legitimately bad actors that use shell companies for tax evasion, money laundering, terrorism financing. That is all true, but it is actually just an explosive number of legitimate businesses that use anonymous companies for potentially socially beneficial ends. So if you look at registries of who owns New York City condos, you'll see a lot of LLCs. You'll never really be able to find who the true beneficial owners are. And same is true for a lot of e-commerce entrepreneurships.
Thanks, Will. All right, so now we've had a couple, Sandy Tarrant, Samantha Prince, and Michael Murphy all expressed a great desire to hear a little bit more from Priya about her class, and specifically said, can you share the in-class exercise you do with your students about how they might bootstrap their imaginary business, or is it just a discussion on the topic generally? Oh, you're muted.
I know. I just was really hoping to get through this whole presentation without having to be on mute, but oh well, right? It's an actual in-class exercise. It's usually the second half of class, and the way after we've sort of had a moment to sort of whiteboard and discuss all of the structural issues. And then because we do work closely, both I worked in West Virginia and here in America, and I work closely with the student incubator. We have all of these types of books in our in our clinic library, right? That are the types, because we learn things as lawyers, and then entrepreneurs like Google a blog post, and then they come at you with some like crazy question that you're like, that's not how that works. So in order to help make sure that we are speaking the same language. I have these students read these types of books, and one of them has this really great breakdown of, how much money you should be raising at each phase, right, of your business. Like how much you should be bootstrapping, how much you should be raising in your friends and family round, right? To then get to like, okay, now you're going to go and actually get your first, big pool of private money. Like how much are you going to raise that way? And so we use that as a model. And then I tell my students, okay, go. How are you going to bootstrap $50,000 to $100,000? Let's figure out how you can do that. How much is your, how much is your, 1997 Nissan Sentra worth, right? Like how much, where do your parents live? Can you ask them to take out a home equity loan, right? Do they own their house outright? So that's the type of steps that we go through to try to figure it out. And then I had a slide which I did not include in my deck, and I compare it to the money that's handed out in business planning competition. So we had a business planning competition at WVU, and the grand prize money was $10,000, right? And so I compare that to if you went to the University of Michigan, what's the prize money for a similar competition, right? And what is the prize money for a similar competition an hour and a half down the road at the University of Pittsburgh, right? So we really do that kind of robust analysis and say, okay, so then you can't bootstrap, $50,000 on your American Express credit card or your Discover credit card. So how else are you going to get that money, right? And if it's, usually they have an idea of what type of business they want to start. So it becomes, okay, so then if you can't do it, is there bartering? What are the laws involved in that? So that's how we kind of get from point A to B.
Thanks, Priya. Sounds fascinating. So we had a couple of other questions that kind of related, and I think a combination of directed at Paige and Jordan, related to the money that is available, state money and federal money for entrepreneurs. For Jordan, is there any evidence whether that money that's allegedly for entrepreneurs goes to incumbents with connections? There were some other questions about the federal and state money. And then Mohammed Badisi said, Paige, interesting point about state funds. I wonder if they would also insist on more investor-friendly. Oh, wait, sorry, that's different. We'll come back to that one. So I guess the first two questions are for Jordan about empirically, where does the money go? Does it go to entrepreneurs, or does it go to connected and entrenched incumbents?
Yeah, so I want to also just be clear on something. I talk about incentives. I'm not always talking about money per se. Like some of it is, of course, state funds or federal loans or things like that. But a lot of it is also just sort of like things that you put in your regulations that benefit a company in a particular way. So for example, tax incentives. Like nobody's writing you a check, so we can't monitor that as easily. But maybe you take a deduction on your taxes, or you get a credit or something like that. Or maybe you get exempted from some sort of registration requirement from some agency, or there's a lot of ways this can play out. I haven't seen kind of comprehensive, there may be one out there, I'm not saying there isn't, but I haven't seen anything recent that was sort of a really comprehensive look at all of these things. But I have seen sort of, there's been some good work on sort of whether things for small businesses actually go to small businesses and what small business means. Turns out that has a lot of different meanings in different places, and a lot of companies that you wouldn't necessarily think of as being small business get counted. So I think there's certainly plenty of slippage, but I would hard pressed to give you a really strong statistic that I would want to sort of stand behind and say, this is the number.
And I think it's probably the case that, we should remember that it is possible to be an entrepreneur with connections. So you can be entering an industry for the first time, you can be starting into a new area, but, and still, you have connections from your previous life, your previous perhaps work in government or work for a big incumbent in some other industry. So I think that would be another confounding effect.
Sure. And also, like, maybe you start off as an outsider with no connections, and then you start to succeed and you have a great pitch and you're a great company and you're inspiring and you pick up support. So I mean, that can also be a little bit tricky too. Like I would count that as a success for the outsiders. There's what you want to have happen, but like that would be hard to catch in an empirical paper. Data is horrible. It's very messy.
Yeah. So a famous quote that I like, just on not apropos of anything other than just empirical work generally, Ronald Coase, who you all probably heard of and dread the name of, but he had a really funny quote once. He said, "Numbers don't lie, but if you torture them long enough, they'll confess to anything." So there's that. Anyway, so there was the question that it was sort of tied in with those, but it was to Paige. And if there are state funds that are going to entrepreneurs, is there any difference in the terms? Are the funds that come from state, do they have more or less investor-friendly terms than money that comes from venture capitalists?
Sure. Yeah, so great question. And I think the answer is a bit counterintuitive. You would think that because it's state-backed and it's coming from public money, that they're more tolerant of loss and that they're trying to do this for a public purpose. And so you would think maybe that you'd see company-friendly terms. But actually, a lot of people I speak to locally, at least about the state funds here in Ohio, point to more investor-friendly terms. And that's largely because these state funds can kind of get away with it, that they can draft these crazy contracts and put these somewhat onerous demands on the companies. And I don't know exactly how that came about. If I had to guess, I would say it's because these different funds are each trying to prove themselves. And so they're trying to be careful with the money. They're still sort of run like venture funds. And so with the MDs sort of being able to play around with the contracts and term sheets and knowing they have this upper hand, they started drafting very investor-friendly terms, and that just hasn't changed over time yet because there's not enough private competition. And in fact, now private competition has gotten so used to public money being available that there's an expectation that if you're going to invest in an early stage startup here in Ohio, for example, that there's going to be public money involved as well. And so, yeah, again, something I think to watch, but at least that's what's happening here in this state. And I've heard echoes of that in other states, but something to examine.
Thanks. There was a question for initially for Paige, but also could be for anyone. Oh no, I guess sorry, it wasn't for Paige, it was for Priya. Do you know are there any repositories for the type of innovative classroom exercise that you engage in that you're aware of? Whether it be at an institution, whether it's a group of law professors who have started pooling their resources so that younger law professors who are, who want to start their careers doing this from the beginning can have a place they can go to look to try and get their feet under them in terms of doing this type of exercise.
Yeah, so I think from the transactional clinical world, there are a lot of resources from the AALS clinical section, but there's also the University of Missouri, Kansas City runs an entrepreneurship law listserv that has a variety of resources and exercises for both the doctrinal classroom and the clinical classroom. And I'll say that I teach both, in the clinic and in a traditional doctrinal class, and I've been able to modify this for some of my more practicum related classes. So those would be the first places that I would check. I'm also happy to share the materials that I have. We've done a very similar exercise, a little bit more fun, and in some ways using Theranos as an example, like comparing, sort of the access and reputation and cachet that Elizabeth Holmes was able to use versus, the 16 Black-owned women entrepreneurs who have raised $1 million in venture capital. Like, that's it, right? So I'm happy to share those materials. Feel free to email me. But if you're looking for broader repositories because you have the time, in which case I envy you, and you should come to my house and watch my child whenever you have a moment. Those would be the clinical section, and the eShip listserv from UMKC is where I would start. Thanks,
Priya. Does anyone else want to opine on that? Know of any places where there might be a repository of innovative classroom exercises?
I'll just make a brief little pitch for the AALS Clinical Conference, which is in the spring. So typically in April, end of April or beginning of May, around there. There are a lot of sessions that are geared towards faculty members sharing exactly the exercises they do or demonstrating it. I've picked up a lot there, and if you're able to attend, I really encourage you to do it. And it's virtual this year, so it should be easy to do from home.
Great. Jordan, you had a question you wanted to pitch to Will, I believe.
Oh, sure. Yeah, great. Thanks. So, Will, I really enjoyed your presentation. It was very interesting. And the one thing I kind of come back to is it seems like the benefit of protecting privacy here is that you're doing something unpopular, you can't get beaten up for it. So you gave the birth control example. I think back to the NAACP trying to keep its listserv private in the litigation in previous cases, like that sort of story fits. But at the same time, if your goal is to sort of root out bad actors who are doing things that are shady and owning things you don't know they own and kind of doing behind the scenes stuff, I don't see how you can square those things very well. And I know that you kind of talked about how you'd want to balance them, and I think conceptually that makes sense. But can you talk a little bit about how you actually would go about balancing them, other than having, say, the government can look but nobody else can look, which maybe is sort of what we had, and I don't think that's what you're suggesting.
Yeah, it's a difficult issue, but I think there are some principles that we can sort of follow. One is to not defer to the chartering state for guidance on ownership anonymity. So if I'm somebody who's trying to do, money launder in New York, I can just form an entity in the Caymans or BVI or Wyoming. And why should they have a right to regulate this? This is not sort of the internal affairs between shareholders and managers that we're familiar with. That's the whole basis of why we defer to the chartering state to derive corporate law. So I think the jurisdictions that are affected by these bad actors should be the ones that regulate the appropriate level of privacy. I don't necessarily think there's a universal guidance for every country and every jurisdiction. I think they can make up their own minds about the appropriate level of how they want to balance this. So if they want to live in a place where they want full throttle privacy, then maybe they don't want any level of ownership disclosures, even to the government. But if you want to balance it at a level where it encourages certain types of unpopular, morally contestable enterprises, you might not want a public registry where anyone can just access and look up who formed and who the actual beneficial owner of an LLC is. So I think it just depends on the jurisdiction. I haven't come up with a solid normative guideline on this yet. This is mostly a descriptive project thus far.
Gotcha. Can I follow up at all? Is that okay?
Sure.
I think that's interesting. So I think your point about having, kind of shifting the locus of some of this makes sense. You have a Wyoming or a Delaware in a pretty different spot than a New York is, and that makes sense. On the other hand, though, part of what you're talking about was kind of like people being able to move to a spot that fits their preference for privacy and sort of that system sort of working out what they want to do. But I guess I would say that, like, one, I'm kind of a little skeptical that people are going to move based on that basis. I mean, you hear that in other places too, but there's just so many confounding variables like tax and do you like the beach and like many other things like that that kind of are hard to square. And then on top of that, I would also throw in that I think a lot of calls for transparency come from sort of the political arena, where you're worried about kind of like dark connections, like things people can't see affecting the political outcomes. If you're kind of counting on the political outcome to regulate the economics, but the people in politics like outside the system can't see what's happening in the system, that seems like maybe it's a problem. I was just curious if you had any more thoughts on that, because I really liked your locus point a lot.
Yeah, I mean, it's interesting. I mean, the other sort of layers of actors that are at play are state governments and small offshore jurisdictions that really heavily rely on forming these entities as part of their state government revenue. So this is going back to this age-old debate of corporate charter competition. Do we really want to leave up this body of law to to lawmakers that are essentially captured by the private sector? Some say this is a race to the top, some say it's a race for the bottom. It's normatively unclear when it comes to ownership anonymity. So I take your point, and I'm certainly going to think further about it, but yeah, I haven't come to an exact conclusion on that yet.
And Roberta Mann pointed out that some of these same issues come up in the context of multinational corporations, and perhaps even more so since you don't have to move the entity, you can just form a new entity and move on from there. So, but Paige, you had a question you wanted to ask Will as well.
Sure. Yeah, well, I just want to say I really enjoyed your presentation, and in our current era, it's an ambitious thing to talk about the upsides of shell companies. So I admire what you're doing. One question I had was, have you started looking at the different disclosure requirements in these different Caribbean nations? From my very small amount of experience doing a single tax deal that involves shell companies in a number of these different jurisdictions, I was surprised at what kinds of things need to be disclosed to different governments. So I think like Barbados wanted to know who the ultimate beneficial owner was, but Bermuda didn't care or something like that. And have you started looking at that or mapping that?
Yeah, I have a couple of crack research assistants that are gathering ownership, because this is an area where there's a sweeping global legislative reform. So a lot of the offshore quote unquote tax havens have actually been pressured by Europe to adopt really high disclosure laws. So I think the Europe is the side where everything has to be public registry. Not every prominent offshore jurisdiction have followed their approach, but have been pressured in recent years. And there are a lot of voices in the United States that say that we should adopt something very similar to Europe because of people like Paul Manafort, because of all these leaks that link nefarious activities to offshore shell companies. So yeah.
And Will, one more question from George Cohen. It says, Will, are you aware of any cases or situations in which the undisclosed principal, device, and agency, as opposed to anonymous membership, has been used to prevent discrimination against the principal?
I'll have to, can someone explain what, can you repeat the question?
Yeah, I'd be glad to read it again. That are you aware of any cases or situations in which the undisclosed principal, device, and agency, as opposed to anonymous membership, has been used to prevent discrimination against the principal?
Yeah, I'm not aware. I'll have to think a little bit further about that.
We're kind of at a lull in the questions, so I thought I would. I've been kind of saving some thoughts I had just in case I wanted our panelists to be the focus of our discussion, but I've had some thoughts, so I thought I'd share them. Maybe moderator's prerogative. So it seems to me that just on the general principle of entrepreneurship, it requires nimbleness, and I think Jordan in particular kind of gets to this with his discussion of complexity. Because one way to think about markets is it's just a way of conceptualizing the trillions of potential customers and suppliers in the world and all the possibilities for transactions. So you have to be quick and you have to be paying attention in order to take advantage of those opportunities. But even if you're paying attention, even if you're quick, there are often barriers to being able to take those opportunities. And I mentioned gratuitously Ronald Coase earlier, but now I'm going to return to Ronald Coase, who the actual research and not the really terrible summary that most law students get in terms of the Coase theorem, which Ronald Coase hated. But Coase said, he said, yeah, in a world with zero transaction costs, maybe this would happen. But most of his work was saying transaction costs are everywhere. These barriers to transactions are everywhere. They are omnipresent. And what we ought to be doing is we ought to be looking for ways to reduce or eliminate those barriers. And so what I've been thinking is all of the panelists have been identifying barriers, whether it's in terms of Priya's discussion of these structural barriers that existed forever. So people from marginalized communities who have great ideas, and yet there are all sorts of things that keep them, they see the opportunity, they want to take it, and yet they can't because these structural barriers are there. And so, how do we move forward and break down those barriers? Again, Ronald Coase would have said it in terms of transaction costs, right? How do we reduce those transaction costs so the individuals who have these ideas can act on them? And the point is that it's phenomenally beneficial for those who are able to take those advantages. And so individuals from marginalized communities deserve every right, they have every right, or should at least, have every right to take those opportunities and make their lives better. But what's important, and what Ronald Coase pointed out, was it makes everyone better off at the same time. And so to the extent that we can break down those structural barriers, we reduce transaction costs, and we improve society. Jordan's comments about complexity and how that complexity can keep individuals who see an opportunity from being able to take it. And sometimes the complexity is needed, but sometimes that complexity is intentionally put there to protect entrenched incumbents. And obviously those two situations are different. And so we ought to be looking for opportunities to take away the complexity that is designed not to protect some important social goal, but just to protect entrenched incumbents and allow the nimbleness that will make our society better. Now, Will, the discussion of anonymous companies, I thought was fabulous, because there are direct and specific examples of those barriers. A transaction that would be beneficial for both sides of the transaction, except that one of them has some bias that would keep them from doing what's best for themselves, right? And so allowing for anonymity allows both parties to be better off, and we'd like to think over time kind of breaks down those transaction costs and those barriers as a general rule and makes society better off. And then with Paige, it took me a little longer to figure out how transaction costs were relevant. But as you can see, this is sort of where my brain resides as a law and econ guy. But it dawned on me that you've got those barriers in between the coastal VC community and the Midwest VC community. And I imagine one of the questions that showed up in the chat earlier had to do with whether or not these are generalizable. And I think it has to be, because what these are cultural barriers, cultural transaction costs that make it, someone's got, extraordinary leverage in the Midwest that they wouldn't have on the coast. Why? Because there are geographic and there are cultural transaction costs. And so I guess my question would be for each of you, if you could identify the most important thing that we could do in the legal realm to reduce transaction costs and improve not only the lives of entrepreneurs from any community, but also improve our society, because then every individual has a opportunity to succeed, what would it be? And I apologize, I've gotten us under 3 minutes, so you'd have to be quick if you have an answer. If not, that's okay too.
Sure. So I think the thing that I would first point to, and it's already happening, is the availability of really good form contracts and explanations of form contracts, not hidden behind paywalls, not steeped in language that lawyers in other jurisdictions can't understand, or maybe even accessible by entrepreneurs who don't have lawyers, but really good form contracts for entrepreneurs to use with investors or to use with friends and family. I think that helps them structure well. And then related to that, again, more accessibility and availability of click it and go type legal platforms like LegalZoom, but more specialized. So like Clerky and Gust, that make it possible for startups to cheaply set up and to do it right so that they're not shooting themselves in the foot at the foundation level.
Thanks, Paige. Anyone else?
Sure, I'm happy to jump in. First, I just want to say you should not apologize for invoking Ronald Coase. I think that's great. I'm a law and econ guy too, so I'm totally unbiased. But yeah, so that's my first point. Second, I just want to kind of highlight what Priya's doing over there, because it just sounds so important and great. I think that to fix the problem, people have to know about it, and you have to know, like, you need legislators, for example, to know about problems that people who aren't them are experiencing. Like, if you're a legislator, you're probably not an entrepreneur. Some of them are, but not most of them. It's a different group of people, and the people there, there are a few people who have both lived in like a very rural area and also very urban Detroit. Like, that's sort of like a small Venn diagram, and how people think about other experiences is kind of a big step toward improving this. I think this is actually an area we can find a lot of common ground. So I think that's just really terrific. And I want to end on like a positive note, because I'm an optimist, and sort of a life choice at this point. And that's to say that I think one thing that helps is sort of culture. And I think if you see people around you doing something, then it tells you that you can do it too. And also you have people you can ask about, how did you do this? So it sort of like gives you more opportunities. I would say that it's a tricky problem, but I think every step you take that makes it better kind of feeds back into itself and can help make it better further. So even if it takes like a long time, Priya students probably going to become legislators tomorrow, maybe, I don't know. But even if it takes a long time, I think it's all helpful and it kind of builds on itself and you can get this kind of virtuous spiral upward. So that would be my hope for the future, is a virtuous spiral upward.
Yeah, and I'm sorry we've run out of time, but I do need to say, like, we talk about it and Priya's doing it. Like Priya, every time she has this discussion with her students, she is reducing transaction costs in the lives of those individual students. So
you can do it too, right?
Yes, exactly. So more of that. But in the last 7 seconds that I have, I want to thank, we've had a fantastic panel. The questions and the discussion in the chat have been absolutely fantastic as well. Thank you all and have a great rest of the conference.